In these situations, there are three general risk mitigation principles, or as I like to call it, they're three legs of the MSP risk mitigation stool, right? So if you have a stool, you have 1, 2, 3 legs that prop up the stool and give it support. Number one, you have cyber insurance, or generally liability insurance for MSPs, commonly called tech E&O, cyber liability. There's a number of different names, but it's cyber if you want to just make it simple. So insurance, contracts, you have a good contract between you and your customer. And third, best practices. I'm going to talk about all three of those in due course. If you have all three of those and all three of those legs of the stool are operating together, I hate it when managed service providers get sued, especially when they get sued for stupid reasons that could be completely avoided with a little bit of modification, a little bit of best practices, some good contracts, and a few other tricks that we can that I'm going to share with you right now. And this is all in a hope, a plea that the number of cases that we are seeing right now continues to go down. I somehow think that that's not going to be the case just because there's a lot of new MSPs that are out there in the market. There's a lot of companies that are claiming to be MSPs that are winding up getting sued, if you can believe that. And so if this is an interesting topic to you. If you're an MSP business owner, if you run an MSP or an executive in MSP, maybe you're just in charge of risk for your managed services practice. Well, this is the episode that you want to pay particular attention to. As I said, I've talked about this in previous episodes where over the last probably year and a half, 2 years, I've been involved in a handful of cases where I've been brought in as an expert witness to give testimony about managed services best practices. And you might ask, well, why would that type of testimony be needed these days? Well, when you have an MSP or a company that someone thinks is an MSP, and you have a customer and they think that they are working with an MSP, or maybe they really are working with an MSP, all this stuff will make more sense in a bit. And there is a belief from the customer that they are to get a particular type of service, and the company, the MSP, thinks that they're delivering a certain type of service, and those two ideas don't match up, you've got a problem. You've got a potential for disaster. You've got not only the potential for disaster, but you have a very real likelihood of miscommunication and a false sense of what each party is delivering and getting out of the relationship. And that's a recipe for disaster and for bad outcomes, not just litigation, but many other negative things that you don't want to have happen. What I want to do is talk about I'm not going to name names, but I'm going to talk about real scenarios involving real companies and the issues that were raised in these situations. And I'm going to explain how you can avoid them. Part of them is a legal issue, which we'll talk about. Part of the avoidance discussion is going to be around best practices, but it's really about how to use both of those together. Working in concert will greatly enhance your ability and your chances of either avoiding a lawsuit altogether, or if you find yourself in a lawsuit, anyone can be sued for anything these days, the chances of increasing your likelihood of winning will go up greatly if you follow these steps. So let me talk about two general scenarios that I'm seeing right now play out time and time again. And not all of these involve actually getting to litigation. Some of them get settled beforehand. Some of them are just the threat of litigation or legal action if certain behavior isn't taken, right? Like a customer might demand money from their MSP because they feel that the MSP harmed them in some way. There's two general areas of legal friction as I see it. Number one, there is a breach, a data or security incident, and the customer says, I didn't do this. I'm going to blame my MSP and I'm going to go after my MSP to make me whole. In which case the MSP gets involved, the MSP's insurance company is likely to get involved, and then it escalates from there. So that's fact setup number one. Setup number two is transition of services from one provider to the other, right? So you have a customer, you have an MSP, and you have a customer who says, I don't want my current MSP, I want to change to another MSP. And during that time period, something bad happens. Could be a breach. It could be a series of, I've seen billing issues come to a head. I've seen issues such as demand for information, data, transfer of licenses. Lots of crazy stuff. So, but all of that leading to ultimately litigation, where the customer or the new MSP says, I expected something from the old MSP didn't do it, and therefore we're suing. And then the old MSP says, wait a minute, I have no right or obligation to give you the thing that you're asking for. We're completely innocent in all of this, right? So those are the kind of two main fact patterns that I see happening quite commonly today. Again, both of them are avoidable, and we're going to get into that shortly. So if you find yourself in those types of scenarios, there are some very simple things to do right now, not tomorrow, not next week, not next year, today. If you don't have any of these things, you put down what you're doing today and you start working on these things today, because that is going to save you a ton of time, a ton of money potentially, and you'll sleep better at night just knowing that you're taking these steps and you're taking them seriously. The scenario in fact pattern number one, right, where there's a data or security incident and the MSP is, all parties are pointing the finger at the MSP, and the MSP is, left with, they have to defend themselves against what they're being accused of. That could fall into a couple of different scenarios. One, the MSP was actually, at fault. They were negligent, perhaps, or they were at fault. Not always the same thing. And then it could be a scenario where the MSP was completely not at fault. They did everything that they should have done, and still the customer had a data or security incident, and they're still looking at and pointing the finger at the MSP. I'm going to talk about both scenarios. In these situations, there are three general risk mitigation principles, or as I like to call it, they're three legs of the MSP risk mitigation stool, right? So if you have a stool, you have 1, 2, 3 legs that prop up the stool and give it support. Number one, you have cyber insurance, or generally liability insurance for MSPs, commonly called Tech E&O, cyber liability. There's a number of different names, but it's cyber if you want to just make it simple. So insurance, contracts, you have a good contract between you and your customer. And third, best practices. I'm going to talk about all three of those in due course. If you have all three of those, and all three of those legs of the stool are operating together, what do I mean by operating together? I mean that they are all contemplating and aware of each other. Right? I have seen, and I'll give you a good example of what happens when you're missing one of the legs of the three legs of the stool. I've seen a number of scenarios where the MSP had insurance and the MSP had a contract, and the MSP was not behaving in a manner consistent with our industry's best practices, and that issue came up. It came up. I know because I was there and I was a witness, and the other side was saying, well, is this really what best practices is? Because there's what is in the agreement and there's what should be done. And that is a very real issue being litigated right now, right? Despite the fact that you have all of these cyber frameworks all over the world sprouting up all over the place, right? You've got frameworks in Europe, you've got them in Australia, you've got them in Asia, you've got them in South Africa, in Latin America, in North America. They're all over the place. Presence of all of these cyber frameworks points undeniably in one direction, which is parties, entities, organizations should be behaving in a relatively consistent manner when it comes to IT and cybersecurity. And that is what is now coming into conflict with agreements that say the parties are going to do this and only this, and the customer, let's say, said that they were only buying this from the MSP, right? So let's say the agreement says, I'm going to provide best effort IT support, but I'm not going to back up the customer's data. I'm not going to provide MFA for the customer because the customer doesn't want it and the customer's not going to pay for it. So in cross-examination or when asked by a judge, well, how come the MSP didn't deliver multi-factor authentication? Isn't multi-factor authentication a best practice in your industry? To which I would say, yes, of course it is. It's very much a best practice. Well, Mr. Weaver, how come the MSP in this situation did not provide it? Isn't that a direct cause of the customer's breach or data event? You could say, I would maybe say, yeah, it is. And that's why the customer should have purchased that from the MSP. But in this case, they didn't. They specifically said, no, I don't want this. I don't want my data backed up. I don't want MFA turned on. I don't want MDR, EDR. And so I've made these arguments before. And in those situations, the judge typically will have a moment of understanding that there is now what is expected and there is what is approved of by the end user. And that's where the conflict comes in, where the customer says, I'm signing an agreement with my MSP. I'm paying my MSP every single month. And I did all these things, and yet I still had a data breach or a security incident. Why does this happen? I thought that I was paying my MSP to stop this. That's a real belief out there. And you're not going to solve that belief just by having a good contract. You actually have to be doing those things. Now, I want to call your attention to two things. There is the best practice of the MSP and what the MSP ought to be doing internally. That is a non-negotiable. What do I mean by that? I mean, it doesn't matter what your customers pay you for or don't pay you for. You as an MSP are expected to do certain things. So if you sell backup as a service, and if you sell MDR, and if you sell MFA to your customers, and 50% of your customers don't buy those things from you because they don't like it, they think it's a hassle, they think it's too expensive. That's no excuse for you, the MSP, not to do those same things on yourself. What I mean is you should be using MFA, MDR, EDR, backup on your own systems to make you resilient. You get what I'm saying? Those things for you are non-negotiable. You don't have a choice but to do them. That is separate from you being successful or not in selling those services to a customer who should be doing it. But because you don't run that company, you don't run your customer, all you can do is present that as an option and say, look, I think you ought to have this. If you don't do it, right, you're not going to be compliant. You're not going to likely have access to a claim for your insurance if you ever have a data breach or a security incident. So those are some of the issues that are now becoming litigated, and they're now coming to a resolution. And by the way, the outcomes of these cases are, for the most part, very positive, meaning that the parties that hire me to come in and explain this are generally the ones that are making a claim that we offered them this service, the customer declined. Because the customer declined, this bad thing happened. It's not our fault. That's the MSP's argument. And so I'm there to support the MSP to say, look, this is in fact true. This is a best practice, but the fact that the customers rejected it, said there's nothing more that the MSP could do. The MSP can't force those types of things onto a customer that's unwilling to do it. Even if the MSP bundled all of those services, right? The customer ultimately has to accept it and be willing to go along with those services and receiving them. So that is a very real scenario. And it's a mixture, like I said, not just of having a good contract, not just having some insurance, but you have to be practicing best practices. You have to have that built into the DNA of your MSP business. That's why certification is going through the roof these days, because certification like MSP Verify is a way to not only understand what managed services best practices really are, but it's a way to test whether you actually have them inside your MSP business. And you can prove that you have it by showing customers your MSP Verify report. That's the third leg of the stool. The third leg of MSP risk mitigation is being able to demonstrate to a customer you're doing things the proper way. And when you have all three of those legs of the stool, you are in a very you're a much better position to defend yourself against claims like the MSP wasn't doing something appropriate. I want to be very clear. If you are an MSP and you have all three legs of the stool, you have cyber insurance, you have good contracts, and you're certified, you have the MSP Verify. If you get into a situation, you could still make a mistake, right? Having all three legs of the stool does not make you infallible. It doesn't mean that you are perfect and you never make mistakes. We are all human, we make mistakes. But it certainly makes it a lot easier, and it certainly makes it a lot less likely, less common for those types of MSPs to get into situations like this. Not saying it wouldn't happen, just saying it's less likely to happen. So that's the first fact scenario. The second scenario, which is a very, very common thing, and it happens so much. I don't like, this is the dominant scenario today in terms of it happens to MSPs of all sizes all over the world. And I'm surprised that the litigation isn't 10 times what it is today. Transfer of services. One MSP transferring from themselves to another entity. So much can go wrong. And I'll just go through some of the potential litigation issues that I've seen arise. Number one, failure to pay. What do I mean? Failure by whom to pay? The customer stops paying, right? At this stage in the relationship, we're talking about the MSP and the customer are in a bad relationship. Forget whose fault it is. Let's just assume that they're both unhappy with one another. They want out. In some cases, it's both parties want out. The customer wants a different MSP. The MSP wants a different customer. Okay? So whatever led up to that, you're there. And now you have a scenario where you have almost always, it's the MSP being asked to give over power to another MSP. It is less common. It still happens, but it's very rare. In fact, I don't see it that much at all happening anymore. And that would be going from an MSP to an internal IT department. I know it does happen, but all the scenarios that I hear about are very positive scenarios where it's a certified MSP. We know that they're having let's say a customer gets acquired. There's a larger entity. They actually do have the capability of an internal IT department. And so they take on ownership, and the MSP kind of loses control of that relationship because of, the factors, and there's a transfer. That's not what I'm talking about. Those are not the situations that I've seen litigation arise. I'm talking about the MSP has this customer, and the customer might say something like, hey, we want you to help us, transfer to another provider. And then the MSP would say something like, well, we're happy to do that. Here is our professional services project service agreement, because we're not going to get paid. This is not a managed service you're asking us to do. You're asking us to do things that go beyond our managed services relationship. So we would like you to agree to these terms. That's where I see a lot of friction. The customer says, well, I'm already paying you every month. Why am I going to pay you more just to transfer services away from you? I don't like you anymore. I want to go to another company. Why am I going to pay you more? and then things devolve really fast. Here's a tip. Don't do a thing unless you're covered legally. And that is to say, if you have a customer who wants you to help them transfer their services out, if they're going to do things like say, hey, we want you to go and do a bunch of manual work. We want you to spend a bunch of time doing things that are going to be necessary for us to have services transferred to another service provider, to our internal IT department. You have to have authority. You have to have authorization to be able to do that type of work, because it's almost certainly going to be non-managed services related work. It's going to be project work, billable time work. That's fine. I think you need those types of agreements. If you don't have one, you should have one made immediately. That should be a specific, separate agreement to cover the work that you're going to do, because a lot of things are going to happen in that transition period that are going to be outside the purview of whatever your agreement currently says for your managed services offerings, right? Does this make sense? Your managed services relationship is governed by your MSP agreements. Project work, including transition work from one MSP to another, that's not managed services. That's something else. Call it project. Have a separate agreement. The separate agreement deals with that relationship. If the client doesn't agree to that, that's a problem. That's going to be a problem. And, I don't want to advise you on what to do in a hypothetical situation, because I know everything, every scenario could be different. But I would really be cautious of doing much, if any, work for a client who is unwilling to sign a project agreement with you, because that's going to leave you unprotected, not just in terms of your hours spent, but it's going to leave you unprotected in terms of it's not authorizing you to do things that, like I said, are outside the modern or the managed services relationship that you currently have with them. That's going to be ending soon. So that's one scenario. Another scenario that will come up during the transition period that I've seen cause a lot of problems: transfer of credentials. So in a modern managed services relationship, it's not uncommon to see the MSP have Microsoft 365 licenses being sold to and consumed by the customer. It's not uncommon to have backup credentials, MFA technologies, EDR technologies, things that are being used by the MSP to deliver the services to the customer. Let's say the MSP is transferring credentials to, or transferring service to another MSP that uses completely different technologies, right? Let's say they use a different backup vendor. Let's say they use a different EDR vendor. Let's say they use a different RMM agent. Like, everything is changing. That's a significant move. To expect that you, the outgoing MSP, are going to do all this work for free, right? What we talked about earlier, that's something that has to be considered and negotiated. Number two, there's a very real start and stop point to what you as the outgoing MSP ought to be doing. I'll give you a great example. There was one case where the customer demanded a whole bunch of MSP user licenses to the environment, but they were actually tools that the MSP owned or licensed themselves from those vendors, again, to deliver the managed services that they were offering to the customer. And in that scenario, the customer was, in my opinion, and ultimately the court, I think, agreed, the MSP was in complete right to say, no, you can't have access to our RMM tool. You can have access to the data backups if you use this same vendor we use, right? But we're not going to give you access to our licenses, right? Other new MSP has to bring those things to the table. Makes sense, right? Well, those are the little things that can cause big conflict. And so that's what I said before. You have to have an agreement that articulates those types of things, what you will and what you won't do when transferring solutions and transferring information over to another MSP. When it comes to data, I'm a big believer that unless there's some special circumstance like data backups and things of that nature, that should go with the customer. Those belong to the customer. Now, if the customer says, well, I want you, my old MSP, to transfer all that, into a disk, and I want you to format it, and I want you to then courier it to the new MSP because it's, too big to send over an email or whatever, fine. But the MSP's got to be paid for that, right? Because that's not a typical managed service. When you make, my opinion, unrealistic requests of the outgoing MSP to say, I want access to all of your RMM environment, to your MDR environment, to your backup environment, so that I can go in there and make sure that there's no loss of continuity of service. That is not a reasonable expectation. In fact, that's a huge security risk to grant that, right? And that's exactly what I argued in that case. I said that to have complied with that, the old MSP would have been committing a very serious security breach that would have caused a very significant negative outcome for the MSP. And I said they should never have been asked that, and they should never have done it. Not that they did it, but they would, to have done it would have been a serious breach of managed services best practice protocol. And so those are some very real scenarios that, like I said, are being litigated, have been litigated, and are being settled. But if you don't want to go through the hassle of being a part of history to prove what managed services best practices really are, you want to do the things that I'm suggesting now to prevent the case from even being made. And if you do actually end up in court or in litigation, you're able to settle the case, or at least hopefully have a positive outcome for you, and of something that's costly and ultimately unnecessary and avoidable. So what would I suggest you do? Number one, get insurance. That's a no-brainer. Number two, have your agreements reviewed. And especially if you haven't had them reviewed in the last couple of years, it's probably well overdue. There's so much that is changing in the managed services profession almost on a monthly basis now that your contracts ought to be in a more regular state of review. Our friends over at Monger are doing some fantastic work. If you want to sign up with them, they have a service where they'll not only craft your agreements if you don't already have them. If you do have them, they'll make them updated, and modernized, and they'll keep them in that state so that you have a very current master service agreement and current service attachments or service agreements that you can use to sell your managed services and make sure that they're always embodying the most current legal and managed services principles, if you will. Number three, you have to be able to not only know that you are abiding by managed services best practices, you need to be able to prove it. Because if you ever get in that situation where you're in front of a judge or an arbitrator, or maybe you're hoping to avoid that altogether and you want to present this to your opposing counsel, to avoid, that situation, maybe settle or get out of a legal dispute, you need to be able to prove what you're doing. The legal agreement and your insurance are not going to do that. That's where, if you have something like an MSP Verify report and you give that to a customer and you say to the customer when things go bad, you can read our report. This is what we do. This is what's been tested. This is what we are delivering to you. This is what you agreed and what you didn't agree to. Those types of scenarios can be very helpful to you in avoiding getting to a litigation, right? Getting into court, which can be very costly and very time consuming. So managed services best practice. Are you doing the things that you're supposed to be doing, and can you prove it? Number one. Number two, do you have an agreement that says that very thing is happening? And number three, do you have insurance that is the foundation of all of that? Those three things won't guarantee that you'll never be sued, but it significantly increases your likelihood of winning. And it, I think, absolutely decreases by a fair percentage your likelihood of being sued, because if you're following these best practices, you're going to avoid a lot of sticky situations, and you're probably going to avoid working with customers that are risky, don't value the services that you are providing, and only look at you as a risk mitigation tool themselves, meaning they're looking at you, the MSP, as I'm going to do whatever I want to do, and I have my MSP to make things whole if something goes bad. All right. MSPs are not insurance companies. We know that. We've talked about that for many, many years now. Right. Insurance companies are insurance companies. They sell insurance policies. MSPs are outsourced IT management and security. That's what they do. If you don't take advantage of the services they offer, that's not their fault. That's your fault. That's you as a customer. You own that. If your MSP did something wrong, then they should be held responsible. I'm 100% in favor of that. So to conclude, these, in my opinion, silly litigation scenarios are 100% avoidable. Nearly all of them by the MSP sticking to their guns and really just keeping with their principle of, today especially, having the three pillars, the three risk mitigation pillars for MSPs in place, and sticking to a firm application of those principles to all customers, new and existing. That means if you have customers that deviate from what you are comfortable with, if you have customers who say, you know what, I don't want to pay for these services. I only want to pay for these services, and you know what, and we'll figure things out. That's a risk to you, the MSP. And not only is it a risk, it is a foreshadowing of their perhaps likelihood to hold you accountable for things that they do or things that they didn't do, and use you as a scapegoat. And if you're not capable of dealing with those issues today, early on, they can become very costly, expensive, time consuming, draining events down the road. And I don't want to see that. You don't want to see that. Your customers, they don't want to see it, believe me. And so I hope this makes sense to all of you out there. If you have questions, this is a very tricky scenario, a very sensitive scenario. I get it. Talk to your lawyers, certainly, first of all. If you have questions about best practices, insurance, managed services contracts, we're certainly happy to help you guys. Take a look at our friends over at Monjur. They can help you out with the contracts there. But don't ignore this. To ignore it is it's not in your best interest to ignore these things. Get it done. Like I said, do it today. And the sooner you do it, the more comfortably you'll be able to sleep and the lower your risk profile will be. Trust me.